Today I'm meeting with attorney Kelly Peterson of Utah County, and we're going to talk about parental alienation. But before we launch into that, Kelly, for those who are watching, would you please give them your contact information if they'd like to reach you?
Sure, that is www.kmpetersonlaw.net, and my phone number is 801-375-0484.
Now, we are very fortunate to be speaking to you because you bring a perspective to the subject of parental alienation as both a former government-employed guardian ad litem, and then as a private guardian ad litem. Is that correct?
Yes.
And now you're in private practice for yourself, where you'll often run into those same kinds of situations, as well as a host of other family law situations and divorce. Is that right?
Much more often than I would hope, but yes.
All right. And so I was so grateful that Kelly was willing to talk to us because he has a wealth of experience that I simply don't have, but that will help other people that think there might be parental alienation going on, that to find out maybe that's not the case. You could have a very acrimonious divorce, but not necessarily be dealing with a parental alienation problem. Or you might be one of those parents who is at a loss as to what's happened. It's like, I didn't expect this, but now I'm being branded public enemy number one, and it seems to be well received. What can I do to defend myself? And you're going to talk a little bit about what parental alienation is and is not, and that if it is something that you're suffering from as a parent, or your children are afflicted by, what it is that you can do to effectively prove your case in court. All right, so take it away and just start with wherever you feel people who are new to this because they think something's wrong and maybe can't put a name on it, what they should be looking for and what they're going to be experiencing, and their children.
Sure, and I'll begin by saying there is a large body of literature out there that defines parental alienation and describes it in much better detail than I'm going to be able to do.
This is just an overview, right?
Right, and so this does not supplant any actual research on that, but as an overview, there's two basic categories of alienation that I have seen on a regular basis, and that is, there's overt alienation, and these are the obvious kinds of things, disparaging the other party in front of the child or to the child, reminding the child of broken promises that the other parent has made, trying to make it seem like they are a better parent than the other party.
Complaining to the child about all the terrible things that are happening as a result of the other parent.
Exactly, discussing the litigation with the child, and then it becomes a little bit more subtle when they pretend that they are concerned about the other parent, but what they're really doing is highlighting the other parent's flaws. For example, dear God, please bless Mommy won't be such an alcoholic anymore, in a prayer, or well, son, I just really, I love your dad, but he's just making really bad choices right now, and highlighting that flaw for the child. With that overt kind of alienation, or alienating type behaviors, sometimes it's intentional, and sometimes it is simply a lack of education on the part of the parent that's doing it.
And would you also agree that sometimes a parent may not realize the effect it's having? Some parents might say, well, they are being honest, like, well, mom's got a problem with alcohol, but they may not convey that to the child, depending upon the child's age or situation, in a way that actually generates concern for a child, and empathy, and also a healthy dose of caution, as opposed to, yeah, mom is someone I shouldn't trust. Mom is someone I don't want to love.
Absolutely. In fact, a lot of alienating type behaviors that occur are done with the best of intentions. But you have a parent that doesn't understand child development and doesn't understand the burden they're placing by telling the truth to the child. Parents often feel like, well, the truth is a defense to anything. As long as I'm telling the truth to the child, then I'm doing right by the child. And that's not necessarily the case. There's all kinds of things you do not tell a child even though it's true, because he or she is not developmentally capable of processing that yet. And so you wait until they're older to tell it. You don't tell a 6-year-old, you don't go into the birds and the bees necessarily with a 6-year-old. In the same way, you don't tell your 13-year-old about the truth about the flaws of the other parent.
Let me ask you this then, because clearly that is something people need to be aware of so that they don't incur the wrath of the court just about petty squabbling and things like that. Now let's change gears to the not only overt but hardcore overt kind of alienation that is so well managed, so masterfully contrived that it's getting people to believe it, whether it be the children, the neighbors, other people that are influential in this divorce case, perhaps even the commissioner or judge. And what are some of the things you've seen? And then let's talk about what its effect is. And then, for those of you that are wondering, we're going to then move on to how one makes a case for parental alienation if you're on the receiving end. So whatever you want to start with.
With intentional alienating type behaviors, the same kinds of things that I described earlier, only doing it with the actual purpose of alienating the child from the other parent. There are certain steps that can be taken and should be taken. Unfortunately, sometimes they cost money to do it. One thing that should be done in that kind of a case is to get the child into therapy, depending on the age of the child. You're not going to put a 3-year-old in therapy.
And before we get to the therapy, could you give us a few examples of some common alienating tactics that some people may think are unique to their situation, whether they're on the giving or receiving end? Some things that you've seen over the course of your career, and if you'd like, you can even talk about, it's like, well, I saw one that was really bizarre. Again, there's only so much that he can say, but if there's some typical things you can describe, it may be very helpful to people that didn't realize. It's like, I just thought I was having difficulties, but I didn't realize this could be a more serious problem.
So one of the most difficult types of alienation to catch and to prove, but it can be done, is creating a loyalty conflict for the child by hiding behind the child's preference. So the alienating parent, and I use that term loosely, not as it's defined in the literature, but the alienating parent would ask the child, what's your preference? What do you want as far as how much contact do you want with the other parent, or whose custody do you want to be in?
Do you want mom or dad to pick you up after school as opposed from the house, or various things like that?
Do you want to do this extracurricular activity during the other parent's parent time?
Do you want to take mom's or dad's call?
Right.
At this particular time.
And then what they'll do is they will say to themselves and pat themselves on the back, hey, I'm looking out for the child because I'm asking the child for his or her preference. And then they'll hide behind that child's preference. Hey, it wasn't me. I was just doing what the child wanted. Many, many, many cases with that kind of alienation. But the problem is the child is not the person that should be making that decision. Why? The child doesn't have the emotional scaffolding, the internal sophistication emotionally to be able to handle that kind of a loyalty conflict between their parents.
And correct me if I'm wrong, I think when we were getting ready to film this, you also alluded to the idea that it's one day, it's like, do you want to take this call? And the answer is no, because the child might be in the middle of a video game and doesn't want to stop, or may be too tired or something like that. But then there are times, and we can do this in any situation, but on that call it's like, oh, don't want to talk to mom or dad now. Hey, it's another call. Remember that last time, didn't really, and reinforcing that. Remember, you don't want to speak to mom or dad. And they start to actually believe that. Like, yeah, you know what, I didn't talk to mom or dad before. Now it's slightly less inconvenient, but yeah, I don't have to, and then they realize, and this other parent will support me in that, to where it goes to, now I actually believe I don't want to have any contact at all. Did I understand that?
That is one way it can happen.
Yeah.
Absolutely. Another way is just by giving attention. Let's suppose that the child starts saying something that he doesn't like about what goes on at the other parent's home, and the parent that the child is speaking to is doing the dishes or is on the phone or whatever. But as soon as the child starts complaining about the other parent, zoom. Their attention is focused on that kid, and the kid is feeling, oh, great, I'm getting all the attention I want from this parent, and so it gives
and whether
them
conscious or subconsciously, they start to find out, I get what I want and I get the attention I want when I speak badly of the other parent, even if that's not what may be motivating me.
Absolutely
Interesting. Yeah.
And so they begin to feel reinforced whenever they start complaining about the other parent. A surprising number of sexual abuse allegations arise this way, or physical abuse allegations, the same kind of a thing. If the more the child exaggerates what really happened, the more alarmed one parent gets, and because they're not trained in forensic interviewing, again, there's this reinforcement process that goes on, and sometimes that results in false allegations where neither the parent that engaged in the process nor the child necessarily intended that, but it becomes this cycle of reinforcement for a pat on the head whenever the child says something bad about the other parent.
And if you're motivated as the other parent to paint the opposing side in a bad light, even if you think you're doing something virtuous, you may not, but you're still more than happy to generate all this kind of stuff and then run off to the attorney or the court and say, look what happened now, and this is serious. And of course, were it true, it would be serious. But if it's not true, it's not serious, a serious matter of protection. It's actually no, we need to protect the child against you, not the falsely accused abuser.
That's correct.
Okay.
And so with loyalty conflict, the same kind of a thing. If the parent thinks they're being virtuous by saying, "Hey, I'm all about the child, and whatever the child says, that's what I want to go with," but that is putting too large of a burden on that kid, who cannot have he's not emotionally prepared. He or she is not emotionally prepared to take care of that.
Something I didn't tell you I wanted to talk to you about, but I'm hoping you're comfortable enough to cover that, is that where you've got overt, malicious parental alienation going on, as opposed to somebody who may be doing it overtly but just trying to get an advantage but truly doesn't have a black heart. But do you see mental illness as an aspect of the alienator or not? Do you see the parents that are the worst at it, the most malicious or the most damaging to the child, or that falsely accused parent? Is there some element of mental illness or emotional or personality disorders, or can it basically afflict all parents across the board more or less the same? I don't know the answer. I mean, and again, I know you're not a clinician, but from your professional experience, do you have any observations on that?
Any parent can do this, whether they're mentally ill or not.
Do you find that the worse it is, there's often a mental illness component or not?
Mental illness.
I don't know the answer, by the way. I'm not trying to look for that. I just was wondering, because I don't know either. I was wondering if you've seen something where it's usually when we finally got to the bottom of it, we also found out that mom or dad who was doing the alienating had big troubles of his or her own as well. I just wondered.
Well, I think mental illness can aggravate it. And I think that depending on the mental illness, that makes their efforts towards alienation a little more clumsy, a little more overt, as opposed to somebody who has a personality disorder but is very smart and has little empathy for the child and more just anger against the other parent. They tend to engage in some of the more subtle kinds of alienating behaviors that are nevertheless harder to prove and more effective in the long term.
Well, that's a perfect segue then to, so what do you do depending upon how sophisticated the alienator might be? What does the person on the receiving end who's trying to defend him or herself in the eyes of the court as well as protect the children, how does a good case for proving that? Not only to prove the wrongdoing of the alienator, but also to prove the innocence of the falsely accused. What are the things that people do well, and what are some of the things people fail to do or do poorly?
Well, I'm going to start with the more overt kinds of things, the disparaging, the reminding the children of broken promises, things, discussing the litigation, that kind of a thing. The first step that you generally take is education, and this is what the divorce education class is supposed to get at. But because you have to rule out that the person is just ignorant. And if you rule out, okay, they've had enough education either from the court lecturing them or from the divorce education class or that kind of thing, and yet they're still engaging in this behavior, you can rule out ignorance as the reason why they're doing this. And so, and once that's done, you can also use third-party professionals. a special master, a therapist. You can have a forensic evaluation, whether it be a parental fitness or a visitation evaluation or custody evaluation, to help sort that kind of thing out. Of course, those are expensive, but depending on the degree of alienation, you may need to do it.
Do you have an opinion as to how effective they are, given the costs of these forensic evaluations, whatever form they may take?
I think it would depend on, that's a pretty fact-specific question. It really depends on the case. And so I would probably have to have a specific case before I weighed in on that. I can be very effective, and then sometimes it's not very helpful at all. And so there you really are relying on the experience of your attorney to determine, is this the kind of remedy that would be best fit for your case?
And would it be safe to say that in some cases you don't know how effective it was until after you've taken the plunge?
That surely would be. One of the things, though, that is, and now I'm going to kind of go into the more subtle kinds of alienation and the hiding behind the child's choice and that kind of thing. How do you catch that? What you have to do is prove patterns of behavior over time to the court. So many people make the mistake of simply alleging, "Hey, judge, they're alienating me or my children against me," and then they don't take the time, effort, an enormous effort, to demonstrate what the other parent is doing to do that.
What do you mean by enormous effort?
Well, in order to demonstrate patterns of behavior over time, you have to collect and document, this incident happened on this date, this incident happened on this date, this incident happened on this date, over a long period of time. And it's going to end up being hundreds of incidents. And then you're able to kind of categorize the behaviors of the other side.
Cannot connect dots until you have collected enough dots to show that pattern exists.
That's correct.
Okay.
And here's another mistake that people that are trying to prove alienation engage in. They start spinning their wheels by speculating about the motives of the other parent. Don't worry about the motives of the other parent. You can't prove it. All you can prove is their behavior. So focus on the behavior. Whether they're doing it intentionally, ignorantly, recklessly, it doesn't matter. The only thing that matters is the effect on the child.
Let me stop you there, though. What if you've got a judge who says, okay, well, I'm convinced that this alienation is happening, but I believe that it was ignorant. Therefore, I won't protect the child to the same degree I would if the same alienation was going on, but I knew that it was, or I believed it to be intentional or reckless. Do you follow what I'm saying there?
The response to that would be, Your Honor, this person lacks insight to such a degree that they just don't get it. And they're not likely to get it in the future. Therefore, their behavior is likely to continue. Therefore, my argument still stands.
And is there an analogy to saying, look, if you're physically abusing the child, whether it's ignorantly abusing or recklessly or intentionally abusing, the solution is still the same when it comes to the child. Protect the child, remove the child from the harm. Now, maybe the ignorant abuser can be reintroduced sooner because that person could be educated and has a heart of gold. And maybe the other parent might have to be taken to the woodshed or something like that. But yeah, the reason I ask is because it seems like there's sometimes this question is like, well, as long as it's ignorant alienation, then surely this person will come to his or her senses.
Yeah.
Okay.
Not at all. If it's done ignorantly, then you would expect the behavior to stop shortly after some kind of education.
When it's brought to the attention of and then addressed.
And if it continues, it's either intentional, reckless, or there's such a profound lack of insight in the alienating parent's behavior that he or she just doesn't get what they're doing, and therefore it's likely to continue. You can't fix somebody who doesn't recognize that they've done anything wrong.
You've been in practice for how long?
I graduated from law school in 2000.
Okay.
And then practiced in Oregon in a general practice firm for about 3 years after a 2-year stint at the Utah Court of Appeals, and then spent 8 years as a district court guardian ad litem. Most guardian ad litems are in juvenile court, where DCFS and the state are involved. But there were a handful of us that only dealt with high conflict cases, divorce and custody cases in the district court level.
In the district court level. Okay, so that made you kind of special, to be quite honest.
Well,
is
because, unique anyway.
Yeah, unique, yeah. All right. In the time that you've been in practice then, what do you, have you seen any kind of shift in the opinions and receptivity of courts to parental alienation? Has it been something that's held steady? Is it becoming less accepted, more accepted? What do you see?
In my experience, the courts are becoming more and more educated about it, as are the attorneys as well. For example, it used to be years ago that everybody focused on PAS, Parental Alienation Syndrome, and threw that word around a lot in court. And then Parental Alienation Syndrome, as opposed to parental alienation. They're not necessarily the same thing.
And one in capital letters and one in lowercase letters.
That was kind of debunked as a theory in the literature, and or at least as a forensic tool that could be used in court. It was more for diagnostic purposes and therapy, but it wasn't something that should be used in court because it tended to focus more on the motives of the alienating parent than the behavior. And so over time you've seen a shift where I've seen a shift where the courts have begun getting that and focusing more on the behavior than on the intent.
Correct me if I'm wrong too, parental alienation syndrome was something that, and we're referring to the work of Dr. Gardner specifically, that has been called into question by non-agenda driven academics who have said this isn't a special syndrome. What he was describing was in fact happening, but it wasn't a syndrome that could be differentiated from other pathologies. Would that be an accurate statement? In other words, there were things happening to children were being harmed, but it was not something that was simply unique to its own syndrome.
That sounds about right.
Yeah, okay. So in other words, and this is important, we're saying that parental alienation in lowercase letters is simply that, hey, there are acts and omissions of parents that are harming children and not serving their best interest. But that doesn't necessarily mean that the parent doing it has a sickness or some kind of psychological pathology that is in fact parental alienation syndrome. It could be reflective of other things. They're doing harm, right, but it's not a parental alienation syndrome.
So, and therefore don't get hung up on the nomenclature.
Whether it's better myself. Yeah.
You focus on the behavior and the effect of the behavior on the child, and that's it. Now, how do you prove that? We talked about, how we need to show patterns of behavior over time. How do you do that? In the alienation cases that I've been involved with and tried, and one of the things that I have my clients do is a chronology of events. And I have them go back through all of their text messages, all of their emails, their diaries, journals, and everything. And then I have them write, on this date, this happened. On this date, this happened. On this date, this happened. And get out the entire thing. If there is anything that has happened that they think is noteworthy, it gets into one document.
And do you have them describe how bad it made them feel?
Not necessarily, no.
And why is that?
On the stand, yes, but but I don't make that a main.
Yeah, and the reason I ask is because I think a lot of times people realize is like, look, for the benefit of the court and the attorney, it's tell us what happened, tell us the date, the who, what, the when, and the where. But your feelings as to what it meant to you largely aren't going to be important because the judge will make the determination as to how serious it is. And saying I wept bitterly, it's like, well, from occasionally that may be good to know just how much of an effect this has had, but I'm again focusing on the child, not
exactly how it affects the child. That's paramount. How it affects you, the court's not going to find that particularly legally relevant because it's not the best interest of you that it's determining. It's the best interest of the child. And so once we have, and so when I have them do that chronology, if they make a statement in it that can be supported by a document. A text message, an email, an affidavit written by the other side.
If worse comes to worse, another human being.
Then yes, or a statement from somebody else. Then that gets attached in that chronology as an exhibit. and they specifically make reference to that. Now, once we have all of that, one of the most helpful things that you can do in an alienation case is depose the other side, the other parent and their spouse, if they're married. And you begin that deposition by, after going through the preliminaries, asking them how they feel about your client. What are your feelings about? Are they a good parent? And then whatever they say, it doesn't matter. If they're saying they're a good parent, great. If they're saying no,
great.
Let's explore that.
Right.
And name every single reason why you think it's not. And what that will do is they will begin to reveal their attitudes about the other parent. Then I ask them.
By the way, do you ever see judges and commissioners say that's not relevant? That person's attitudes and opinions of the other parent aren't relevant?
No.
Okay.
No, I don't, because it goes to the court can infer motives. Proving motives is that you can't get inside somebody's head, but the court can infer it based on their attitudes.
All right. And I didn't mean, so you were saying, so you've done that, you've gotten their attitudes and opinions on the record through the deposition.
We asked them, have you ever engaged in this kind of behavior or that kind of behavior, and go through all the alienating kind of behaviors they're worried about, and get them to commit to yes or no. Once they commit, and most of the time they'll commit to no, then again, I'll start then exploring, loyalty conflict. Have you ever engaged in this behavior with a child, hiding behind the child's
knowing,
choice?
of course, they're going to try to put the best gloss on it, but you can still, they may crack sometimes, they may slip up sometimes, or it just may be, it's like, look, this just isn't credible after a while.
Right. Or they will say, well, yes, absolutely, I believe that the child's choice is paramount. And so I explore that with them. Why is that? And they just think it's obvious. Well, it's the child's choice. What else matters besides that?
Or who am I to make a child feel a different way or make a different choice? Right?
Exactly.
Like that.
And you get them to commit themselves to that position, and that becomes significant later on. So because that demonstrates that they are unwilling to do anything against the child's choice when it comes to their relationship with the other parent. Once the court realizes that that's the truth, then the court's going to put a heavier level of scrutiny on the behavior of the other parent. Then I also talked with them about who has the greatest degree of influence over the child. And if it's the custodial parents that's the alienating parent, then they're in a catch-22 at that point. Because if they say, well, I am not the person that is influencing the child more than anybody else, why not? You're the custodial parent. Shouldn't you have the greatest degree of influence over the child more than anybody else? But most of the time they'll say, yeah, that would probably be me and my spouse. And therefore, if the child is being influenced against the other parent, once they've admitted that we are the greatest influence over the child, that rules out a whole host of well, it may not rule it out, but it increases, again, the level of scrutiny of the court on the influence of the parents. It could rule things out,
but at the very least it calls into question some of these other potential influences.
So I get them, this is very, very basic, but I get them to commit themselves to their feelings about the other parent, the degree of influence they have over the child, their feelings about the child's choice, and how much the child should have a choice in everything. And that's once I've committed them to that, then I go through with them this chronology. On this date, did you do this? Was that helpful to the child? And if so, why or why not? On this date, this happened. And was that a good example of co-parenting? And go through the entire chronology with them. Now they're going to give some frustrating answers, but obviously one of the purposes.
Oh,
of
and they're
the
going to lie
position.
sometimes, human nature being what it is.
Of course.
And so, yeah. And does that fluster you? Do you try to nail them to the wall?
No. Whatever their answer is good.
Yeah. Folks, keep that in mind. I mean, your lawyer, you may know that you're being lied to, but that's something you're collecting for the record for various reasons. You're not going to try to dig down sometimes. You'll just get that. If they're going to lie about something, you may be able to objectively prove that's a lie. And if you question them enough, they might be able to weasel their way out of it or say, oh, I realize they're going to catch me. I better change my position and say, oh, actually, let me tell you the truth.
That's
when
right.
you could have caught them and questioned their credibility.
If you have a good attorney, there's really no way to defend, for the other side to defend against bad behavior. Because either they did it and they admit it, in which case, great, or they lie and they don't admit it, and if you have the evidence to catch them in a lie, great. Or if they admit it but they claim that it's the right thing to do, then they are demonstrating lack of insight into the effect of their behaviors on the child.
Yeah, they're a danger to this child whether they realize it or not. And
so it can be used one of several different ways, and a good attorney will know how to use that.
Do you make any use of experts above and beyond the forensic evaluator, like a custody evaluator or a psychological evaluator? Do you do anything else?
So the third-party professionals I end up going to most would be a child's therapist. But a child's therapist, you have to be very, very careful with how they're used. They cannot engage in what's known as dual roles. They can't. In other words, if they're going to engage in therapy, they cannot turn around then and use their expertise to give a recommendation to the court or to answer a legal question for a court. That is known as forensic work, and it's unethical for them to both engage in therapy and do forensic work at the same time. So if you have a therapist that says, I've been treating this child for a long time and this is what I've been seeing in therapy sessions, and therefore I recommend that the court give custody to the other side, the court's going to consider that therapist to be a quack. And so the main reason that I would have the child in therapy obviously would be to help the child.
Right, so
but
what good's the therapist then? Now, by the way, I think I know the answer, but for those watching who might say, you just said they can't make recommendations, what can this therapist do?
What they can do is document where the child's at and the statements of the child. Now, there are various ways of getting the statements of a child in to be admitted in court. One of the ways is through an expert. Experts are allowed to form opinions based on hearsay. And so the hearsay of the child can come in if the hearsay was relied upon by the therapist in performing their duties or in the forensic evaluator. The other thing you can do is take the notes from the therapist or have the therapist speak to a custody evaluator or to a parental fitness evaluator or some other forensic evaluator, and the statements of the therapist and the records of the therapist become data for that evaluator to rely on. And so you can get the therapist's information admitted into court through the custody evaluator or the other forensic evaluator.
And so to avoid that conflict of interest between therapist and forensic evaluator, you can get the notes and the observations of that therapist in front of the finder of fact, which is our judge or commissioner. And then the judge or commissioner can be the one to make a recommendation, so to speak, in the form of, I think I know, based upon this data, what is best for the child, and this is what I'm going to order.
Absolutely.
So it isn't a big some people might say, oh, well, if they're not going to make recommendations, what would the court care? Actually, I would think the court, in some cases, would prefer just data over a recommendation, because that way that judge or commissioner can say, oh, that's the reason you're feeling this way, or this is why you made these findings or conclusions or things like that.
Absolutely, because some judges will give a great deal of deference to a forensic evaluator or a therapist, particularly if they're new judges and in their former career they were prosecutors and
they're out of their depth.
Right, and they're just learning about child development, they're just learning about custody issues. But if you have an older, seasoned judge who no longer thinks that the custody evaluator is necessarily smarter than he is or she is, then they're not necessarily going to give a lot of deference to the custody evaluator. They might or they might not, depending on their personality.
But show them the facts.
And then they will make a conclusion.
Conclusions. Is there anything else that is part of a winning strategy when you're the one who is falsely accused by the alienator and or your children are suffering because of the alienator?
What can a parent do? Is that what you mean?
What can you do to prove your case in court?
Okay.
You've gone through the deposition, you've gone through the chronology that the client prepares, you've gone through the chronology that you ask in depositions and or in the course of trial, and then the use of experts and the differences between forensic and observational or clinical. Anything else that you do?
Okay, so once you have all of that data, let's suppose that we've gathered every scrap of data that we can get.
Your client's given you what you wanted, the opposing side's given you what you wanted, the evaluator or therapist has given you what you've requested.
Well, first you funnel all of that data to the evaluator
Okay.
or to the therapist. And the reason why is this. When a forensic evaluator does an evaluation, they're not going to ask as hard-hitting questions as your attorney would. And not as long. Usually the interviews last a couple of hours, and they're about more general topics, and every once in a while the evaluator will be confrontive with the other side, but they're going to be largely throwing up softballs. But if you give a transcript of a hard-hitting deposition to the evaluator for the evaluator to rely on, this is asking all the questions that the evaluator wished they would have had the time to ask, and in a more hard-hitting manner than they typically do it.
Or in some cases more direct.
Right.
Simply because an evaluator cannot ask certain direct questions because it will taint or influence the outcome improperly. Okay.
Right. And so evaluators love receiving a deposition like that, particularly in an alienation case. So once you have all of that data, then it depends on what stage you're at procedurally. If you're at the beginning of the case and the temporary orders hearing is coming up, obviously you'd submit it then. If you're near the end of the case, you most of the time will just need to get that thing to trial as soon as possible, unless you're able to resolve it in settlement negotiations or mediation.
I appreciate that. Now, for those who would like to, who realize this strikes a chord with them, and they think this is something that I thought a game I couldn't win, or a battle I couldn't win, more appropriately, where can they talk to you? Now, do you practice exclusively in the Utah County area?
No, I also practice in, I've been to a number of counties throughout the state. My most typical counties that I practice in would be Salt Lake County, Utah County, Wasatch, Juab. Mm-hmm. But I've also gone farther afield.
All right. For those that would like to get in touch with you, and as we wrap things up, please give them again your name and your contact information, and thank you so much for the time you spent with us today.
My pleasure, Eric. Again, that is kmpetersonlaw.net and 801-375-0484.
Thanks again.
You bet. Thank you.